Good evening, everyone. Welcome back for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my fair co-host here, Julio Vela.
Anytime I'm with my posse, I'm ready to ride into any town.
This is your posse?
To make a show.
Abigail Anastasio and Todd DuPont. That's your posse?
I will ride in with Abigail Anastasio and or Todd DuPont to any town in Texas and to any jury trial in the U.S. of A.
Are you armed and ready to go, Todd?
I'm always typically prepared and ready.
That's good. That's good. Abigail, how about you?
The defense is always ready.
There you go. Maybe not prepared, but always ready, right?
Always ready.
Todd and Abigail will be with us for the next hour, ladies and gentlemen. If you want to call in, 713-807-1794 is the number. We'll try something different tonight. If you want to call in now. I don't know. Try something new. Why not? We don't have to restrict it to the last half hour of the show. Also, if you want to send us any tweets at HCCLA_TV, you can tweet us your questions and comments there as we get the set a little still going here. We had some shoulders in the shot. It's all right. I like to look at your broad shoulders there, Julio.
I have very broad shoulders.
You do. How would you spend your 4th of July?
I spent my 4th of July...
Inside, avoiding the rain?
Inside, 3/4. I'm talking my whole clan getting cabin fever, and then around 4 o'clock opened up, and we were singing 4th of July, America the Beautiful, the whole works.
Yankee Doodle Dandy?
Yankee Doodle. I even told my wife, I said, wife, Kim, take down the Roman candle pictures, because it's the classic thing of, if we get fined or cited with anything, we're done. Because we were popping off over in Pearland in Manville. And I thought to myself, we should probably take some of those pictures down because some of them were questionable. But kids had a good time.
Good.
4th of July, you know.
Abigail,
one in the books.
what did you do for your 4th?
I stayed at home by myself, but I had several guests come visit me, and I was living the American dream because I just bought a new house that I saved up for forever.
Congratulations.
And so that's nice. Other than that, I didn't really do anything remarkable.
Okay, so at 9:30, directly after the show.
I was in bed by 9:30.
Directly after this show.
Nothing really exciting like that.
Everybody needs to go to Abigail Anastasio's new home, and there's going to be a big party. So everybody watching, go ahead and go over there. We'll be there.
Get the pre-party on.
Have a good time.
Dang.
I
Todd,
know,
did you have
but
a Cajun blowout
I'm living
for,
all the way in Tomball, so I don't think anybody wants to drive out there. So if you want to go to Tomball, come on over.
You're not going to make it there by 9:30 after you leave the show.
Sadly, I'm not cool anymore. I used to be, maybe 20 years ago. The allergies got the best of me, so.
So you're down for the count.
I did eat 2 hot dogs, which I was cool with.
Okay, you brought that up. I want to know. This is a question for you guys. Has nothing law related. This is just purely randomness.
Please.
Best way to prepare a hot dog.
The way I prepared it yesterday was in the chili.
Okay. So I'm just talking about general basic preparation. Here's the way I see it. There are really only 5 ways to prepare a hot dog, and there really should only be 4. Okay? Number 1,
We're all ears.
boiled.
That is correct. That is the correct answer.
proper way to boil to prepare a hot dog.
Correct answer.
Number 1 is boiled. Number 2, grilled. No, any objections from that?
No objections.
Not grilled onions.
Both are good.
I
yes.
was going to say boiled.
Number 3, third best way is to fry it.
Did not choose to do that.
No. Number 4, bake it in the oven.
No.
I'm just saying ways, okay? And the 5th is to microwave it. I think 5, you should definitely never microwave a hot dog. Like, it shouldn't even be there. But I saw it on somebody's list, and I'm like, it's just not an acceptable way to prepare a hot dog.
You didn't accept my way where I...
No, that's technically boiling it, I think.
But in chili.
Yes, which is acceptable.
Okay.
Yeah,
So
that's
cool
like boiling.
Wait. I'm not sure I understand what you mean boiling in chili.
I put chili on my stove.
And then you cut up the hot dog.
No, I cut it up. I put
It's whole.
the wieners in there. I pulled them out, put them on my bun, relished
Completely
them,
acceptable.
and ate them.
That actually might be better than boiling them in straight.
Well, because I don't have to use 2 pots.
Yeah. Yeah.
And I like a chili dog.
It's all about
Who
economy.
doesn't like a chili
in the
dog
kitchen.
with a little extra onions?
Well, I did cut up onions.
There you go. There you go.
All right. Well, that's the way I did.
I do a wet towel, wet paper towel.
Don't tell me.
Microwave.
it.
No.
I do a wet paper towel, put the wieners in the
No.
middle, make sure everything's covered, use reverse osmosis, put it in the microwave. and call it a day.
No, you can't microwave a hot dog.
They come out like
That's nasty.
Yeah, that is nasty. And they will explode.
well.
More times than not, they will explode. I just think that's an unacceptable way. It should not have been on the list.
Well,
But
you know what? My wife loves to boil the hot dogs,
it's the only way to do it.
but she's pregnant, so.
That's the only way to do it. That is the #1 acceptable way to prepare a hot dog for any holiday.
Well,
So
tomato.
get in on this debate,
tomato.
ladies and gentlemen. We want to know. We want to know. So on Tuesday, the Harris County Criminal Lawyers Association sponsored and performed their annual reading of the Declaration of Independence on the steps of the now inoperable Harris County criminal justice system. Well, I guess it's partially operable now, right?
It is.
We got, 4 floors working? So I guess it would be wrong to say.
Most of the top floors.
Yeah, so those are working. This is now the 9th year?
It is.
The 9th year that this has been going on, and it's now a tradition that not only has spread throughout the state, but it has spread throughout the country as well. We've got lawyers who have taken up the torch and taken it to places like New Mexico and Colorado and other places.
Our own Rod Pickman has, somewhere in the 9 years, led the charge to encourage other people in Texas and otherwise, if they were related to us when inception began, to read the Declaration of Independence in the courthouse steps. Of course, this was done on Tuesday all across the state of Texas and in other places, and it's incredible what Rob has done to memorialize such a unique event in our country.
You know what's surprising to me is when you look at the ages, and I could be completely wrong, but it was on Facebook, and so I take it as true. Who knows? The ages of the individuals who signed the Declaration of Independence, it ranged from anywhere from 20 years old to 40. And the idea that the Declaration of Independence from a tyranny can span or can transcend an age, it was remarkable to me. Did you all see that too? Mm-hmm. There were some individuals who were in their 20s. Thomas Jefferson supposedly was in his 20s or
He was like 30 through
early 30s.
Yeah, early 30s, 33, I think.
33, younger than I am, and I'm a pretty young guy. I'm 34. The idea that I would be not only declaring certain principles, but also swearing my life to a document is remarkable.
But also how unique the words are contained in the document themselves, the manner in which they posited words. It's clever, it's unique, and it sent a signal to, to England that we're done with you. I don't know how else to say that.
We couldn't break up with them by a text,
Right.
So.
Or tweet.
Or tweet.
Would have taken.
Or a Facebook direct message.
Gotta send it over.
It actually, the funny thing is, they didn't learn about it until like August 10th.
Well, that's what I'm saying. They had to ship it over the Atlantic Ocean.
Yeah.
They didn't just get, a little dove to take it over or anything like
Facebook like.
Hey, but if Alex Jones had been right, we would have had a second Civil War on yesterday.
that. That was pretty funny.
That
I
was
don't. No.
I want to get this phone call in and see, because I think we have somebody who wants to debate the hot dog issue. So let's get this person on. Hello. Thanks for calling Reasonable Doubt.
Totally called it the JV boils his hot dogs, or microwave, excuse me.
It's unacceptable. I would have said, had JV not said that only an Aggie would microwave their hot dogs. But
But come on, isn't there another way? No one ever put a hot dog on a stick over a fire when you're camping?
Of course.
Of course. I mean, but I'm just talking. Do you set a fire in your backyard and go out and cook the hot dogs on a stick?
One hot dog.
Yeah.
Or two.
I have done that before.
That is a wholly inefficient way to cook a hot dog. One hot dog for a holiday.
If you're
Well,
single.
if you're judging by efficiency, we should all microwave them.
Or boil. You can just dump them in a big pot.
Or into a pot of chili.
Chili. Yeah. Anyway,
I think
Julio
Todd's
has
wins.
Julio.
But there's 6 ways.
Yes, that's true. Julio has let down Longhorn Nation, but
Look. Hook 'em.
whatever.
All right, go back to the declaration.
All right, thank you. So yes, the Second Civil War stuff was pretty entertaining.
I don't know what that means. What are you talking about?
Wait. You didn't follow this?
No.
Seriously?
No, I don't know what you're talking
God,
about.
this is
Many
funny.
people survived
Many
the
people
Second
did.
Civil War.
Yeah. You didn't hear about this?
No.
For us, it got rained out, so it's been rescheduled for a doubleheader in September. Seriously?
No, I
Oh
don't
my
know.
God.
Okay.
So Alex Jones, the InfoWars guy, started tweeting and putting out on social media that the Democrats were going to start a second Civil War on July 4th.
There was a recent thing I
there you
saw on Netflix that said, are the Dems who you really think they are? Are they the party of the people?
No, they're actually vampires. They come out at night.
I think the preview ended up coming out. There were zombies and
Yeah.
vampires.
Yeah.
Is what I thought. And then I thought of Miss Abigail, and I said, maybe. I kid.
JK.
Did you mark yourself safe during the Second Civil War?
No.
I didn't know
None of
I
us are
could
safe.
until I knew that it was uncool to do that. But yes, apparently you could mark.
You did?
No, I did not
Oh.
mark myself safe.
Okay.
I saw this. I was sick in bed yesterday with allergies.
Are you okay?
Couldn't take up
Thank
arms.
God.
It's the African dust.
It is the African dust.
The African dust has destroyed me for like 4 days.
For those of you not in the Houston area, we've been deluged by Saharan dust and a tropical system that dumped more water on us. So in the last 7 days, it's been lovely around here.
All right. So what do we think about what's going to happen recently now with the judges? There's new rulings on the bond stuff from the federal courts. Anybody reading up on this?
So I saw the ruling that came down from Judge Rosenthal, but I have not seen how it's being implemented or haven't seen anything that's going on in the courts. Either of y'all?
I think it's going to amend. Well, it still says that individuals who cannot pay bonds for misdemeanors still need to be released.
But
However,
there's certain misdemeanors that they can set a monetary bond for.
So, for example, assault family members.
Right.
Assault family members are individuals who are accused of assaulting either girlfriend, boyfriend, past girlfriend, past boyfriend, roommate, because the definition of family member in the family code is a little bit broader than what we would expect as a plain reading of the language. And so what the judges are able to do now is set an actual monetary bond for them. And what that will do is not give them a personal recognizance bond. However, I believe it will still allow those individuals who are accused of those types of crimes to be released after a certain amount of time, which I believe might be 24 hours or 3 days, one or the other.
72 hours is the typical.
72 hours with an via an unsecured bond, which is a SOB bond, which is sheriff's bond. In other words, you're not going to be released on an unsecured bond. However, you'll be released on an you won't be released on a personal bond, but you'll be released on an unsecured bond, which means you'll be liable for the money that they present for you if you don't show up to court.
So are they abiding by this?
Yes, yes, and the judges have been abiding by something similar for some time. So the order from the federal agent from the federal circuit says, hey, look, you can't hold people who can't afford bonds in jail. But, and they've also ordered the sheriff, though, simultaneously, that says, hey, for these individuals who don't necessarily qualify for a personal bond, so you're accused of a assault family member and some other crimes that fit within that category, basically threats to other people, we're going to give you a monetary bond. The judge will say your bonds are worth $3,000, but if you can't pay that within a certain allotted amount of time, it used to be 24 hours, and at least at this point, the amendment will say 72 hours, that you're going to be released on what's called an unsecured bond. So
who's going to monitor that?
Well,
why are they putting a time period on it too?
I believe it's 72 hours.
The Fair Defense Act has teeth in well before this lawsuit. Mm-hmm. The Fair Defense Act has teeth that is kind of the grounding network of understanding current bonds in Texas. But it still depends on counties. Harris County has the direct intake. A person could be arrested before a magistrate in 18 hours. Somebody in Odessa might be arrested and not see a judge for 6 days. And then, heck, that magistrate might set a bond that's incredibly high.
Oh, like the one in Waco?
Well, yes. So Harris County is unique, really unique in the state of Texas, where that they have magistrates that are reviewing a bail schedule presumptively reasonable, which it's not, and under scrutiny of a federal lawsuit. But at least we have these people that are brought before a tribunal to have probable cause read to them and a bail ostensibly set, even though today I got appointed a case where bail was set on one case but not on another.
And you're starting to see a difference between what the magistrate's bond will be or the monetary bond that will be from the magistrates to what the actual county court at law judge's bond would be. And you're starting to see conflict between the two.
JB, we're not starting to see this. I never mean to disrespect you. We've been fighting this issue for decades.
Well, I think what he's saying is that there's a discrepancy between the bonds that the magistrates are now setting versus the misdemeanor bail, the bond schedule, but prior to, they were following the requests of the misdemeanor judges more so than perhaps they are now. I think that's what
That's correct. That's correct. And we've seen a pushback. We've seen a big difference. And without, because I'm not going to mention any names on the air, but some of the county criminal court at law judges are upset that the magistrates are either second-guessing or undermining some of the principles and objectives that the county criminal court at law judges are are trying to implement. So, for example,
and then that
Hauled
goes to
before
what
the
Todd
State Judicial
said.
Conduct Commission. I mean,
Right.
wouldn't you start to question some of the practices that you were being told to do if you had to sit there and go through all that?
I think, and there's no way any of us could speak for the federal court. I think the federal court looked at this objectively, cautiously, with all the parameters in front of her, and decided this ain't right. All right. So working from that premise, the idea is like, should these low-level offenders be kept in jail, like as a pragmatic understanding, right? Just for very small-level criminal offenses, right? Well, the idea was resounding no. I mean, Jimmy, you and I work in cases often where people get accused of serious federal crimes and get bond routinely.
Get unsecured bonds.
Right. Well, and
Routinely.
the federal government knows where to find them.
Yes.
Okay. One of the things that's disheartening that I hear is a kind of a lash back against. They say, well, these low-level offenders that get unsecured bonds don't show up, and that messes up our docket. Well, okay, if they don't show up, there's going to be an active warrant for them.
Yeah. Well, the quick solution to that is don't have them show up every 3 to 4 weeks.
Well, and this is kind of
I mean, that's the easy
At some
solution.
point, surely you have to have a person show up.
No, I agree, but you don't have to have them show up 6, 7, 8 times on a case. I mean, it seems to work fine in every other court in America that doesn't require this, where I guarantee you, if defendants only had to maybe come once or twice to court, if for a plea hearing or maybe a status conference or a pretrial conference, I guarantee you that the bond revocation cases would go way down. Way down.
As a defense attorney, what do you think about that, Abigail?
As far as people returning back to court,
Yes.
I do feel that they have unnecessary resets. I feel like it's a financial burden on many people. They have jobs, they have families. A lot of people have transportation issues. Sometimes you can
got
ask.
parking issues.
Definitely. There used to be a line problem, elevators not working properly. Perhaps there's a little bit more understanding and people being a little bit late to court, but as a defense attorney, I do believe that there should be less court appearances. I don't understand why people can't do their homework outside of court. Now, I think the prosecutors are getting better about providing us with the discovery, which was, generally speaking, why we would go to court more often to get videos.
That's
or
true.
Things like that. And now we have access to those without having to go to court.
Right.
And so I just think it's financially, just fiscally speaking, more responsible for us to not have defendants showing up to court constantly.
As a defense attorney,
Agreed.
what are your? As a defense attorney and seeing these who practices a lot in felony court, what is your opinion regarding bail for low-level drug type of offenses regarding bond and bond conditions?
Are you saying that they too should receive PR bond?
Well,
Or is
that's a question. Yeah, and so the federal
Well,
lawsuit.
in a lot of cases they are.
Are they? And what's
Some
your opinion?
cases, I don't know. As far as some of the judges I've approached, I think that they're more open to listening to arguments. Now, one thing that I would say that I think more judges need to do is to revisit bond. But it's also on the responsibility of the defense attorney to push that issue, and a lot of people are not. But once someone's been in jail for a while, it's shown that they cannot make their bond. So I think that there needs to be consideration taken into looking at a reduction, especially when someone's waiting for trial. and they've been sitting there for a really long time, and for a variety of reasons can't get to trial for a while. I mean, the defense attorneys need to be more proactive at pushing
And the
requests
law
for bond
allows them the opportunity to do that, of course. Perhaps maybe they're scared or shy to go ask for relief after 60 days, but the law allows them relief. Of course, they have to understand the law and then urge that relief upon their client. But
I think one time we were on the show, we were talking about, what the solution is if a judge is not willing to give relief. And we were saying how it just the process would take so long to appeal that at that point the case would probably be disposed of. So, I mean, I've had a situation where I had a judge tell me, do not approach again asking for a bond reduction. I was like, well, I'm probably going to, but okay.
Yeah.
I mean, I have to do that for my client.
What have you seen post Harvey? I know, Todd, you have a very heavy felony practice. What have you seen post Harvey regarding individuals waiting for trial? Have you seen trials roll out, or do you find that it's a little bit slower or a little in between?
I'll tell you this, I had a meeting today with a prosecutor friend of mine, and cases that he's prepping were from 14 and 15 for trial. Sadly, the cases that he's looking to try are 3 years or 4 years old right now.
And I would imagine if, on the misdemeanor.
On the state side.
And that's on at the felony side in the district court.
Felony state side.
And I would imagine on the misdemeanor courts, I mean, you're probably on a case that you got picked up for in, let's say, March or April of this year, or even January of this year. You're probably not getting to trial till end of 2019.
I'm getting, for individuals, for example, today that have already been in process on the misdemeanor side in March and April, and now we're in June. So they picked up March and April, now we're June. We're talking in some courts, not all, some, we're talking about March or April, May of 2019.
They give you that setting.
Yes.
Because I had a misdemeanor judge set me, I'm not going to say their name, I set a case this year in that court, and they gave me a this year trial setting, which I thought was silly.
Probably unrealistic.
Well,
and that's kind of the conundrum you're going to be in, right? So here's the new conundrum that adds to that is, we talked for years on the bail side about how people would just plead out to cases because they were being held in custody. And so in order to just get it done with, they would plead out rather than fight the case. Well, if you can't get your case resolved for 2 years and you want to try, if you want to trial on your case and you're staring down a possible 2 years of waiting for a trial, and the state comes to you and says, you know what, hey, if you plead guilty and do a deferred, or even maybe just plead straight up on something else, and they'll give you 6 months or a year probation. Well, hell, you can complete the probation and be done before you get to trial.
That's
Right.
correct.
And you're basically on probation.
Y'all call
You're
in, we ain't got much longer.
Right. I mean, so now you've got that conundrum to deal with.
The other big deal, at least from my opinion, I'm starting to go into courts now, and there are no files. Zero. We're talking.
Oh my God, what do you do?
It's crazy.
What do you do with no files?
There's no. I
Wait
have
for
a
a
name.
long time.
Yeah.
I have I have a name, and before I used to be able to go to the client and get the file, go to the client and say, look, you got this history, you got this, you got that, you're looking at this, here's our plan, here's what we're gonna do. Now, I have a name. I don't even have a cause. I don't have a cause number.
Well, when
Are
we're
you talking about a new appointment?
yeah,
Is
I'm
that
talking
what
about
you're
new
discussing? Okay.
appointments.
when we're appointed, unless and until we're attached to the case, We're at the benevolence of the district attorney who's overworked to share what they can show us on the screen, which means we have to reset, which means we have to make sure there's a bond that's reasonable in place. And we'll see you next time we see you. Please bond out person. And then, yes, they are downloading Discovery on the portal. So we can, but I create a paper file and I bring a file that's comprehensive to the next court setting, and the state has nothing. I have more than they have.
Mm-hmm. Well, I think one of the problems too
Which is incredible.
They are making, you discuss something in court and they're supposed to make an entry into the computer.
Or a note.
But that's not necessarily happening. And there's something about just things that were once written on the file that we won't have the benefit of necessarily being recorded. And that's definitely a problem. I also know that the DAs are a little bit frustrated because they can only look at one file at a time. They can't juggle like they used to be able to and have multiple conversations going on. They have to just, and when you have a large docket, it's just kind of maybe impractical.
All right,
However,
Sounds like a ripe opportunity for a software startup in Harris County.
Well, but look,
Right?
no, but honestly, there's DAs watching this, probably some of the brass, our friends. There's defense lawyers watching this. Where are we at? I mean, I typically agree with paperless files. However, and I've argued on this show, we need to know criminal history. We need, for bail, we need to know criminal history without taking so much time to go through it. Like, even the most proficient prosecutor will bring his or her computer to the desk or to the bench and scroll through. Like an intake, somebody wrote it down. It was a linear understanding of criminal history, okay? Are we taking 2 steps forward and, 3 back?
Well, it's the same thing
That's the question.
It's the same thing when we're arguing magistrate's order for emergency protections. It's the same thing that when we're arguing for MOEPs, for no contacts. It's the same thing that we're ordering for no interlocks. All of these things, bond conditions, it's a big deal. They first show up. We have no bond conditions. They don't have a file. We don't have a file. So what does the judge do? Okay, in an abundance of caution, I'm going to give him everything that I want. And then on the next court setting, y'all come back. And then y'all can pick apart my bond conditions. Well, that's a big problem.
It is.
That's a big problem.
Sorry, go ahead.
No.
I find that the clerks are being really good about attaching you to the case, though, immediately. I know in misdemeanor court it's a little bit more busy. You've got a lot more cases that are new for the day, but at least in felony court, they attach me immediately. And I think that generally speaking, depending on the agency, the OR is already on there. And so I'm finding that it's sometimes the rib's already on there, depending.
Allow me to speak to that. So there was a post that said it takes about 5 on Facebook from Joanne Music. And Joanne, if you're listening, this is you said it was 5 minutes. On the post about 5 minutes before your name can attach. Myself and Cynthia Henley ran a test. We turned our appointment of counsel in to see how long it took for us to then access the individual. Respectfully, it took 45 minutes before we were able to access in the DA portal our stuff. So I know via your post that you said it took 5 minutes or so. Cynthia Henley and I ran a test in the County Criminal Court of Law number 6. She turned her appointment of counsel in, and it took 45 minutes for us to access our portal entries. So I didn't comment on your Facebook post. I didn't comment on any of that. But I feel like it's important for us to talk about the discrepancies that we are finding. It did not take 5 minutes. It took 45 minutes. And that's a big problem when we have 5 court appointments. And, or for example, and if you're at a court that starts at 8:30, that really don't start until 8:45 or 9, and they have to be out by 11.
Yep.
That's a big problem that we can't do anything about because it took 45 minutes. It was, and I'm backing this up via Cynthia Hanley. She can call and she can talk about it. We tested it. It took 45 minutes for us to gain access to the portal.
Well, all right.
That's a big problem.
And that's actually a huge problem. I'm not putting that on Cindy or Joanne's back.
Right, it's not on either of theirs.
Is it because the clerks had so much paperwork?
No,
that-
no. We were like, here, we're coming in, we're going to test it.
This is a technology issue.
It is
look,
technology
we do not have, the system is imperfect. The e-file for Texas was down earlier this week. You couldn't even file. You hadn't been able to file anything since Friday. And so if you wanted to file something, even if you wanted to file a notice of appearance and attach yourself to a case through e-file of Texas, you couldn't do it because it was down. It didn't come back up, I think, till late Tuesday afternoon. So the technology is the problem. I don't fault any of the individuals except for the individuals who sit in the county commissioner's court and the powers that be that set the budget because they're not spending enough on the technology. The Wi-Fi sucks.
Well,
Okay,
they've changed that.
They've changed it, but still, you can't have a system that you can't go completely paperless where you have to file for everything and not have the fastest, the best Wi-Fi when you've got hundreds of lawyers, clerks, judges, all accessing the same internet connection, basically. When everything is in the cloud, when everything is based on electronic access, I'm sorry, county commissioners, I'm sorry, Judge Emmett, I'm sorry, you guys. You guys are going to have to go to Comcast and say, upgrade us, and we're going to have to pay for it because you've got the civil courts, the family courts, the probate courts, the juvenile courts, the criminal courts. Everybody's basically using the same internet connection, and unless I'm wrong, if somebody wants to come in and correct me and tell me that each court system has their own, you know, yeah, it's the same thing, okay? So it's probably the same thing that they use for the entire county.
I believe that.
You know, and so you can't have thousands of county employees, hundreds of lawyers, all sucking off the bandwidth and expect it to work perfectly. You're going to have downtime. And if you want to go paperless, which I'm all in favor of, because when I show up to court, I haven't brought a paper file to court probably in 5 years. 5 years, because I bring it all in this thing, okay? So it's great. It's great for me, because I come and I have cellular that backs up, so if the Wi-Fi fails, I got the cellular that, you know, I can still access.
You're a 0.5% lawyer style.
Exactly. And
Most, I mean, we have people that are
I know.
like old school dudes, man.
Dude, there's still people writing with pencils,
I like pencils.
you know, and
Did you know you can write upside down with a pencil?
All right, that's fine.
So, okay, so we have this.
it's a technology issue.
I agree. It's a complete technology.
Without question.
So now what? So where do we go from here?
Well, but all right, let's finish Jimmy's vein. Then our county, if they want us to be paperless, should have the absolute top end of the idea where you walk in, push yes, you're in, let's go. I mean, Monday I went to court. Our sheriffs, for whatever reason, didn't bring the inmates up. Tuesday I went to court. They had no internet access. That was 2 days down. They're not related. It's just fucking, pardon me, happenstance, Mark. I know. Sorry, dude. But we should not have issues regarding internet access because that affects the clerks, the DAs, me, you.
The accused, mostly. So.
Well, I mean, look, it affects, like I said, you've got, and look, we're a criminal justice show, so obviously our first priority is the clients who are charged in criminal court. But you've got just as many people who it's their day in court for a car wreck case that they've been injured on, that it's their day in court on their child custody case, or their divorce, or their CPS case, or to probate their estate. You've got thousands of people who are down at the courthouse complex trying to get whatever form of justice through our civil, criminal, juvenile, family courts. And if we're going to be completely paperless, then we have to have the infrastructure to do it.
I want to say this to the families of the accused, being one that's down there each and every morning. When we reset cases, if there is an issue like this, it's not that a lawyer like me or we're resetting these cases sadly because something has failed along the way. We show up ready to go. I promise you this. I promise you, we show up ready to go. But often, like I just said moments ago, they didn't bring an inmate up. The Wi-Fi was down, so they can't pull up their offense reports. It's things like that, even small things like that change a day, that offsets a case for a month and a half.
As a defense attorney, Abigail, what are your thoughts on this as far as wireless or paperless proceedings?
Well, we're one of the largest counties in the United States, and we should be setting example for the rest of the United States, and we should have the best of everything. And I don't understand why, for example, our courthouse is not the top priority for the county right now. I mean, one of. It's amazing to me the cost that they're trying to currently avoid is exponentially costing us money in so many ways.
But we know Chris Daniels. I'll call him out by name. Chris Daniels is responsive to us. He is. He's always responsive.
He's not on commissioner's court, which is like Jimmy
to
was
me, that
talking
lays
about.
the blame, and they just gave themselves a raise that they approved for themselves.
So you talked about Commissioner's Court. What do you mean about Commissioner's Court?
They're the ones who approve the budget and find ways, determine how much they have to approve everything. For example, they've been talking about giving a raise to, for example, Todd or yourself, JV, who go down there every day fighting for people, and you haven't received a raise on the wages in how long?
We haven't.
And
we were promised this, by the way.
And that was promised. And
by some of my good friend judges.
You deserve it. I mean, I think that, you see people working hard every day, and they deserve a pay raise, and it's time.
Are you in favor for more of a future courtroom as you practice? Like, as far as futuristic courtroom, paperless.
I think that the case will be worked out eventually. It just, growing pains. And unfortunately, to improve something, you have to go through something uncomfortable for a while, quite often. I think it will work out, and futuristic in the sense.
They should have leveled 1201 Franklin, level it to the ground, and just start back up. They want to put outside elevators, which is kind of weird, Jetsons type things. What are they going to do, right? I mean, it's kind of the same format. There's no windows in the courtroom. It's weird. You get really bogged down in trial in there. So what do they? It's the same. There's only 6 elevators on each side. There's no escalators. There's no stair access unless it's up top, and you have to have secret knowledge of this, right? Like,
I saw somebody go to some secret back elevator and do this. And I almost made a comment like, "Oh, you have a ring. You have like one of them Android rings that like."
They have a chip implanted.
Right,
there,
a little chip. And then they went like, I was like, what is going on? There are people that have access to this building and to these rooms. That's not obviously us. It's not me. It might be you in the future, but it's not. You obviously don't have it yet. But I mean, what?
Look, I'm in favor of a paperless courtroom. I'm in favor of utilizing the technology we have available to us and I think once everybody learns how to use everything, it is a much more efficient system. The problem is that we are in it couldn't have happened at a worse time, frankly.
Correct.
Very true.
Where you have the worst hurricane damage ever to hit this city. Maybe not the worst hurricane in terms of wind and storm surge and all that, but certainly in terms of rain and the damage that it did to the city. Most flooding ever. And so it's been catastrophic. And at the same time that you're trying to implement this new system, you're having to move everybody into temporary courts, basically. So it's a bad situation. It's made worse by the fact that clearly the spending priorities of the county are not within the justice system. That just exacerbates the problem even more because now you're not dumping the necessary funds in to make the system work.
I think the reality is, even no matter how loud this show can scream to people that listen to it, even if every court commissioner is listening to us right now, no matter how loud we could scream to you about this, you don't care.
No,
They don't care. The reason they don't care is after Harvey, I'm not even going to give them the benefit of looking them in the eye right now. They came to a meeting with all of the people that accept court appointments in Harris County and set us into a room, and they said, Clay Bowman said, here's the projected budget and we're over. Clay was being a steward of the data. He was not saying that he believes this. I want to make it clear. And then his idea was that they wanted to cut defense lawyers' funds, which we all literally, when I say we all, there maybe have been about 200 lawyers in the room, and we were just dumbfounded to understand that in a county like Harris County, which is, for court-appointed cases, you're going to find some of the best lawyers in the nation right here. Not necessarily they weren't going to cut our rates, but they weren't going to even contemplate a pay raise. Even though I've been promised by a number of my friends that perhaps we will have a pay raise. That pay raise hasn't come. It's not even about that anymore. It's about honesty and integrity. And if you say you're going to do something, do it.
Well, the reality is that both at a city and a county level, the money's been mismanaged.
Right.
Okay? It's been mismanaged.
Yeah.
Look, poor decisions have been made regarding fiscal spending, and I'm just setting aside what's going on down at the courthouse. Look, after Harvey, what was the article that came out? That they had the opportunity with the rebuild of the Katy Freeway to put the huge drainage channel underneath the freeway, and they didn't do it. I mean, poor decisions are made. They allow developers to keep building in these floodplains, okay? The flooding is not getting better, it's getting worse, okay? It's getting worse all around the city. We get one rainstorm that comes through on 4th of July. And
One day,
and I've got neighbors calling me saying, hey, our house is flooding. Come over and help. I'm like, what are you talking about?
Yep.
I mean, it's getting stupid. And the problem is our elected officials, both at the county and the city level, are terrible.
Well,
they're terrible. They haven't done anything for just basic infrastructure. They haven't done anything for the courthouse infrastructure. They haven't done anything. And you want to talk about drain the swamp? That's what Harris County and Houston needs. They need to drain everybody within county and city government. I'm sorry, but they do. I'm sorry, you guys, you just haven't done squat. You all need to go. And I hope the next time you're up for election, I don't see your faces anymore. Because all that crap you pulled with the PD's office, that was stupid. All the crap you're doing with the criminal courthouse, that you're doing with the civil courthouse, it's the dumbest thing I've ever seen. Putting money for the Astrodome first and telling us that that money has already been earmarked when you could absolutely take that money and move it over and build a new frickin' criminal courthouse, it's ridiculous what you've done, okay? Across the board, they have mismanaged both at a county and a city level in this great city.
And there's nothing for the future. They've not introduced anything that's credible, anything that's definite for a plan as to how they're going to fix what's going on downtown.
And our property taxes keep going up.
So for the next 2 or 3 years, we can expect to be dealing with these kind of things. On a family level, we're on a family courthouse level, and which is the new misdemeanor level, we're walking through buildings that have already been documented for mold and asbestos.
And the fire marshal is there.
Every day, like, just to make sure that everything's okay. Not that it's okay to be there, just that nobody's burning up and jumping off and having to implement their last minute go-to plan where people are jumping off the buildings, off the second floor, and having to jump on like some makeshift trampoline. I mean, so how, on the misdemeanor level, I have no idea how we're going to deal with any sort of future plan, but at least on the felony level, Todd, and the felony level, Abigail, for the next 2 years, 3 years, y'all are going to have, I mean, all of us are going to have to be dealing with this. How are y'all going to deal with it, and what do y'all expect?
Well, what I understand is that it's back to felony courts sending inmates or, people in custody. We're going back to CJC, 17th, 18th, 19th floor. There are some on the 20th floor. We're working in floors that were not flooded or destroyed by Harvey, straight up. There's one elevator that takes you up, and the other elevator bank you can't get to. There's a road sign thing. Like, there's seriously one elevator that you can use in CJC to take you to 4 floors that you can do your business in. We don't know if the mold is still in there.
I can say that I saw them taking out AC filters the other day, and it was really disturbing, the sight of the AC filters.
Then begs the question, should we go to court in the bottom of the jail or into a building that's still not fixed?
Somehow I think there's going to be some personal injury lawyers in the next 20 years who are going to make a fortune off of suing the county over this.
What are the damages?
The measles. It's going to be yet another fund we're going to have to set aside in Harris County to pay for stuff. So they are still paying, speaking of the mismanagement of everything, they have not paid the city has not paid some of the people that they contracted with to bring down to help clean up the garbage. Still haven't paid some of them. And the city, I learned, also has not paid people going back as far as Ike. There's still claims where people are trying to get paid for their work during Ike.
How, if they
10 years
can't,
ago.
if they can't pay the people who are going back in Ike and going back to Harvey, how are the district courts going to handle people who want their day in court? How are they supposed to handle these things?
I think the judges are trying their best.
I
really do. I think that they're making the most of a terrible situation.
I see a lot of them daily. I know Abigail does too on the felony side. I know you do on the misdemeanor side. The judges I see have smiles on their face, and they do their job the way it's designed to be. regardless of the conditions. But the problem is, we all understand the conditions. If you're in cold, you're going to be chilly. It might affect how you think about something. If it's hot, my point is, in optimal conditions, it should run good. We're not in there. We're nowhere near optimal conditions.
How's a judge supposed to run their court, though, in these kind of conditions?
I mean, I think this is the prime time to now start to say, not everybody has to come to court.
You think?
Every single setting. Yeah, I think there needs to be a rethinking of that. I think especially given the personnel issues at the district attorney's office, people are leaving. I hear they're going to eliminate the 2 position. So you're going to have
In felony court?
I don't know if in felony court they are, but I'm hearing that they're going to be sending less prosecutors to court every day, which frankly I just think everybody needs to rethink how they do this system. I mean, on federal cases, I'm able to work amazingly. We're able to still get plea deals done and move cases without ever having to go to court.
Well, that's new to Harris County, though, boss.
Well, because again, they are under the misconception that you have to have people there to hold their feet to the fire in order to get a plea deal. And the exact opposite is true, because plea negotiation between a defense lawyer and the DA and defense lawyer and his client, it is not an optimal ground for doing that in the hallway or in the witness room or in the holdover cell.
It's terrible.
I mean, you just can't do that. People can't make life-altering decisions. You can't give meaningful, in-depth advice to somebody in the not-so-private confines of the Harris County Court hallway.
It's a today only. Today only. He just got indicted like 20 minutes ago.
It's today. Today only. Today only. You can't.
Gallery
today only.
furniture,
We're
man.
moving
Gallery
it.
furniture.
Hold on.
Buy it today, we'll deliver it tonight.
Hey, it's today only.
This guy, I think like the ink is still wet. I can smudge
I
it.
didn't even see the offense
It hasn't even
report.
been scanned in.
Yeah, where's the? I haven't even seen
Slow
the
it
offense
down,
report.
man. Slow it down.
Oh,
Man, our show's almost out of time. We
That's
got 30
Harris
seconds
County
left.
just.
oh man.
We've ran
That
and
has to
raved.
be a clip.
What? Yeah, I know, right?
That has to be a
A
clip.
clip.
It's today only. It's today only.
Some young defense lawyer was arguing with the prosecutor, who I'll remain nameless because I don't know him. I don't know the guy. And the defense lawyer is pointing out how the state couldn't make his case. And the DA looked at him and said, well, we'll just let a jury decide. The defense lawyer looked back and said, dude, you have a job to see justice be done. Here's how you can't make your case. He actually highlighted it for him. And then he just like shrugged his shoulder to him. I was like, wow. A defense lawyer just told you the way to get rid of a case. And you just said, we'll just set it for trial and let a jury decide.
See you in court. That's it. That's all the time we got.
That was
We're done.
fast.
We are done. Todd DuPont, Abigail Anastasio.
Good evening.
Thank
Lawyer
y'all for joining
extraordinaire.
us. Julio, we gonna be back next week? You gonna make it?
We're gonna be back.
All right. Just
Why
making sure.
not?
Yeah.
Lab show, recorded lab show,
Do what?
recorded lab show next week.
Oh, we're doing the lab show.
You're
Second
going to the
part.
lab?
That's apparently what we're doing.
That's very cool.
We'll see.
I like that idea.
Yeah, we had them on last week.
I think the public should
So,
see that.
This might be number 2. That's all the time we have for this week, ladies and gentlemen. We will be back next week with another episode of Reasonable Doubt. Good night.